You're watching The Legal Breakdown. So, Glenn, we are still in the immediate aftermath of Trump having been indicted by the DOJ. Obviously, a lot to celebrate with this indictment and for accountability finally being taken. But there is one sticking point here that really caught my attention, not in a good way. Can you speak on the judge who was selected for this case?
Yeah, we're on a bit of a roller coaster ride here, Brian. The judge is Judge Aileen Cannon, a Trump appointee. Now, the sticking point is not that she's a Trump appointee, though you have to wonder about the ability of a recent Trump appointee to preside over a criminal trial involving charges against the very president who recently appointed her.
Yeah.
But it's more problematic than that. So back when the search warrant was executed by the FBI at Mar-a-Lago, and they found, tons of additional classified documents that Donald Trump had continued to unlawfully conceal from the feds, Donald Trump lodged a legal challenge to the Department of Justice's ability to look at everything that they had recovered from Mar-a-Lago, including the stuff that they recovered from Donald Trump's office and his very desk drawers, where they found some of the stolen classified materials. He lodged a challenge saying there was some kind of privilege that he might have over all of this. So the Department of Justice prosecutors should be prohibited from looking at it and using it as evidence of crime to investigate Donald Trump. That is kind of a ridiculous claim, to use a legal term. However, Judge Cannon is the one who was assigned to preside over Donald Trump's legal challenge of the FBI search at Mar-a-Lago. And what she did, I think, shocked everybody, certainly the criminal justice veterans. She appointed a special master, and she said, I am prohibiting the Department of Justice, the FBI, the federal prosecutors, from looking at these documents, the evidence of crime that had been recovered, and using them as part of their investigation of the possible crimes of Donald Trump. Instead, I'm going to give them to the special master that I'm appointing, a senior judge, and I'm going to have that judge review everything, and then we'll, engage in lengthy litigation to see what incriminating evidence the DOJ might get to look at and what evidence might they be prohibited from looking at. That was an outrageous ruling. In my view, it was an interference in an ongoing DOJ investigation. So fortunately, the Department of Justice, the federal prosecutors, appealed Judge Cannon's order and her ruling that this whole special master process had to unfold. And pretty quickly, a unanimous 3-judge appellate court who heard that appeal smacked Judge Cannon down, figuratively speaking, reversed her ruling and said, nothing that has happened here gives a judge the right to, quote, interfere in an ongoing Department of Justice investigation, and they did away with the special master. That's not just an embarrassment. That is an enormous black mark on the service, the tenure of a federal district court judge. And yet, lo and behold, Judge Aileen Cannon, we just learned, has been assigned the presiding judge over Donald Trump's criminal trial. And she is set to preside at Donald Trump's first court appearance, which is his arraignment hearing this coming Tuesday.
Now, Glenn, given this claim that she had interfered in the case, is it possible that she could be removed? And what would that process actually look like?
Yeah, a great question. So she could decide that because an appellate court unanimously found that she interfered in this investigation previously, the very investigation that led to the criminal indictment of Donald Trump, she might do the smart thing and recuse herself. That is, make the decision to remove herself as the presiding judge. If she doesn't, then the next question is, will the Department of Justice file a motion to have her recused, to have her replaced? And that's an open question. I could make robust arguments, I think, on both sides of whether the Department of Justice should file such a motion. But I think 51% of me, Brian, which is what I always say when I'm trying to hedge my bet, 51% of me says they probably should pursue a motion to have a truly impartial, unbiased, independent judge preside over Donald Trump's case. Because think about it. Anytime Judge Cannon makes a ruling in the trial of the United States of America versus Donald Trump, if it goes Donald Trump's way, what are all of the critics going to say? There she goes, interfering with the prosecution again, just like an appellate court said she did on the front end of this case. I don't think that's good for anybody, not for Judge Cannon, not for the reliability of the result that is reached in the case. Why give people that opportunity to complain about the fairness of the trial or the reliability of the result? I think the best course is to have an independent judge, not Judge Cannon, preside over this case.
Glenn, if the DOJ does move to have her removed and replaced, who ultimately makes that decision?
So first, they would ask Judge Cannon in the first instance to recuse herself. I've had cases as a prosecutor where defense attorneys filed the motion to have the judge recuse themselves for some reason or another. I will say rarely are those motions granted by the judge. Every once in a while, a judge will recuse themselves because they believe they have some kind of a conflict. Usually what that looks like is they might know some of the witnesses or have a relationship with one or more of the witnesses who may testify at trial. But if she refuses to recuse herself, then the Department of Justice could appeal that to the same federal appellate court that ruled previously that Judge Cannon interfered in the ongoing Department of Justice investigation of Donald Trump. Now, there's no guarantee it will be the same 3 judges on that appellate court panel because there are often a dozen or more judges that sit in each federal appellate district. But, that is what DOJ will have to do. They will have to appeal her decision not to recuse herself from the case.
Do you by any chance know the breakdown of the appointing presidents in that appeals court?
What I recall, Brian, and I'm not under oath, so I'm going to ask you not to quote me on this.
Yeah, we'll give you some grace here.
Yeah. I believe me, I will plead guilty to my crime and agree to cooperate if I'm. So I recall that the 3 judges who reversed Judge Cannon, I believe, were all appointed by Republican presidents. And I actually recall 2 of the 3 were appointed by Donald Trump himself, which was one of those moments that sort of breathed a little hope and optimism into the quality of the federal bench, particularly the quality of some of the judges appointed by Donald Trump. Now, the overall breakdown of all of the 11th Circuit Court of Appeals judges, I think it skews Republican more so than Democrat, but I don't know the precise numeric split.
Okay. Glenn, can you just there are going to be people who are watching this and say, well, this thing's a done deal anyway. The fix is in. To what extent does the judge have the ability to impact this case versus the jury members?
The judge has an enormous ability to impact the case. The judge, assuming Judge Cannon remains the presiding judge, will litigate all sorts of motions with respect to the legality of the prosecution, the propriety of criminally charging a former president for illegally possessing classified materials. These are issues that will be robustly litigated. I think Jack Smith will have the better of the legal arguments all day long. But, the judge can really impact the course of a prosecution by deciding what charges are lawfully brought and therefore can be tried and presented to the jury, what charges need to be dismissed because there's some kind of legal infirmity in the way Jack Smith went about investigating or indicting the charges. And then, day in and day out during trial, judges have to make, 100 or more rulings on the admissibility of evidence, on objections, whether they should be overruled or sustained. That shapes the trial because that dictates what evidence will be allowed to go to the jury and what evidence will not be allowed to go to the jury. So a judge, if the judge is trying to help or hurt one side or another, I don't believe most judges do that. I think most judges call balls and strikes the way they see them. But if a judge is inclined to favor or disfavor a party, they can have an enormous impact on the nature of the trial.
Just based on your experience, do you imagine that the DOJ would move to have her removed and replaced?
It's such a close call. I would say because the appellate court opinion was so scathing, and because the appellate court opinion accused her of interfering in the investigation that led to these very charges, I think the safer course is for the Department of Justice to respectfully make the motion and see how the litigation plays out. If they air their concerns and Judge Cannon says, you know what, I hear your concerns, but I can assure you I can be fair and impartial if I preside over the case of United States of America versus Donald Trump, notwithstanding the earlier criticism from the Court of Appeals. And then the Department of Justice decides, you know what, we've aired our concerns. The issue has been litigated. We are satisfied to live with the result and not appeal it. That is one of the options they'll have. My gut, though, Brian, tells me they should probably make the motion and respectfully litigate it and see how it plays out.
And finally, let's end with this. Would that motion be made at the arraignment on Tuesday?
No, that motion will be made well in the future. At the arraignment, Donald Trump will be read the indictment unless he waives formal reading of the indictment, which most defendants do. Nobody wants to sit there and hear 45 pages worth of incriminating evidence about you.
Yeah.
He'll probably waive formal reading of the indictment. He'll enter a plea of not guilty. The judge will decide whether she should set any conditions of release, whether he should surrender his passport, whether he should be prohibited from leaving the United States, and similar topics, I think, will be discussed. And then she will set a next court hearing probably a month or two down the road. She may also set a briefing schedule and set certain dates for the defense to file their motions, the government to file its motions and its responses to the defense motions. So I don't suspect we'll see much of legal consequence go on or substantive consequence go on at Tuesday's arraignment. So we'll start to hear more about motions that are being filed and what position the Department of Justice is taking on this issue, probably in the next month or two.
Okay, got it. Well, obviously a lot of open questions here, and we'll stay on top of all of them. So to hear that legal news as soon as it breaks, make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.